variation and Will's variation type items. So, without further ado,
thank you. I'm not sure how much I'll use the microphone, but if anyone can't hear, just let me know. People in the back corners and so on. So I'm, as Catherine said, I'm a lawyer at Fulton Company here in Kamloops. I went to law school at Queen's just before TRU, otherwise I would have gone here. I started at Fulton as a summer student in 2011, and I've been there, so I started early 2012, and I've been there ever since. So I wanted to thank Catherine for inviting me today. I'm going to focus on, like she said, talking about some estate litigation topics, and in particular, or at least I'll start talking about Will's variation, which I know you guys have just had some readings assigned for today. Not going to talk about the readings, just talk more in general about my perspective when I get a Will's variation case, some experiences I've had, and that kind of thing. So I am solely a litigator. I do a lot of estate litigation. It seems actually be the growing area of my practice. It seems like I pick up most files in that area. I also do some general commercials type litigation, and our firm also acts for a lot of local governments, so I end up with some local government sort of litigation files as well. So for my little presentation today, if anyone has any questions, please put up your hand right away. It's nicer for me if it is as interactive as you guys want it to be, and I'm prepared to answer questions about estate litigation, the things I'm going to talk about, things that are outside that, practice in general, any sort of thing that crosses your mind. So if you want to ask questions while I'm talking or wait till the end, totally fine either way. So I'm going to sort of focus on three areas, like I said, Will's variation, the first one. The second one that I'm going to talk about is the presumption of resulting trust, which kind of, your eyes might glaze over, but it's a big topic in estate litigation and estate planning as well. So I just want to mention that from a litigation perspective. And I'll talk a little bit, I understand you guys did some readings recently on powers of attorney and commonteeship, so I'll talk a little bit about some litigation perspectives on those two topics as well. So Will's variation actions, I thought about these things as if I was talking to a client or to some financial professionals that I've sort of presented to on this before. So I give some basics and I can talk about the litigation perspective kind of thing. Will's variation actions can be brought by spouses or children, including adult children. That's something that rankles a lot of people when they come in and say, "What do you mean I can't, give my money to who I want to, right? Wow, it's a free country, I can do what I want." Well, you can, but then you take the risk that your adult child that you've left out is gonna bring an application, and then a bunch of your estate is gonna get spent in litigation. The other important thing to note, it doesn't include stepchildren who aren't adopted, and this obviously sometimes bothers people as well. If there's no formal adoption, then the stepchild's inheritance is against their natural parent, not against the step-parent. So sometimes that creates some issues as well. When we talk about spouses, that includes what's defined as a marriage-like relationship. So it's a cohabitation of at least 2 years. There's been a lot of interesting decisions on that. I assume you guys cover this in family law as well, but a lot of interesting decisions on that. And a couple of my early cases in Will's variation were involving these marriage-like relationships where the children were saying, "Oh no, they weren't in a relationship. They were just friends or just dating," or in one instance that was kind of funny, they were just roommates. And I had really, what goes into a common law relationship or a marriage-like relationship, there's sort of this pie that this is all the factors that can be considered. And, there's things like, are they economically interdependent? Do other people see them as a couple? Do they actually live together? Do they sleep in the same bedroom? Do they have sexual relations? All those things go into that pie. And I had a great judge in that trial where the children were saying, no, they were just roommates. And then, partway through the trial, it was kind of admitted, okay, well, yes, they were having sex. And then, okay, yes, they owned a pet together. And yes, they went on vacations together. And the judge was telling him at the end of the day, he's like, well, you start off with a pie this big and you say, okay, they were roommates, okay, they were friends, okay, eventually there's no pie left. Like you've admitted everything. So anyway, there's several cases resolving around that kind of concept as well. Were they spouses or not? And it seems like the court's tendency is to find that people were spouses where there was a relationship of some duration. There's even a couple of recent cases where the courts found people were spouses even though they maintained their own residences. And they only sort of, they spent a lot of time together, slept over at each other's places, went on vacations, but didn't actually put all their life under the same roof, right? So those were a little surprising, I thought, but that's sort of, it seems to be the tendency is to find those relationships rather than finding that they weren't. So in a wills variation challenge, if the person it has that standing as a spouse or a child, the court looks at the will and decides whether it provides adequately, justly, and equitably for the person who's claiming. If there's no will, obviously there's no potential for wills variation challenge. So, like I'm sure you guys have talked about, there's the intestate distribution scheme. If there's no will, here's exactly what happens. And there's no way to challenge that on the basis that no, Dad wanted me to have more money, or no, my brother got a bunch of money outside the estate, I should get more. There's no way to vary that scheme. So only if there's a will, you can challenge it. And then you come up against this term, adequate, just, and equitable. It's hard to think of a broader test than what's given by those three words. So a lot of the case history in wills variation is about the courts trying to figure out what that means and trying to figure out what sort of factors are most important and which ones should be applied. So in the Tattern case, which I think you guys read, the Supreme Court of Canada, this is in the early 90s, weighed in and said, we're gonna make this more easier for people to identify. And the court said, you got to consider legal obligations and moral obligations. So with legal obligations, we think of the family law type obligations if they're owed to a spouse or to a dependent child. So if the spouse is a claimant, you think about what would have happened if there was a property division, spousal support, maintenance payments, those kind of things. If there's a dependent minor child, then you think about child support, what the child support obligation would have been. And that gives us some kind of framework to think about those things. But then the court went on to say, and past legal obligations, we have moral obligations. And those are basically, despite the Supreme Court trying to specify and trying to be a bit more particular, are still very, very broad. And the court tells us to consider what society's expectations are and so on. And obviously that's something that really, it really comes down to what your judge thinks is the most important. And so there's all sorts of factors that are considered in these cases. The most important one is probably the size of the estate. And obviously that's a really significant one right from the start, because the estate's really small. There's not much point in fighting about it if you're not going to get very much money, even if you're successful. But obviously, bigger estate means bigger obligations for everybody. And by the time you get to estates of real substance, around $1 million or more, the courts are saying, well, you should really make sure to provide for everyone. You got an estate this big. There's some presumption that you can be more generous to the people that you like more, but you should provide for everyone. So there's that kind of thing comes into play. The age of the parties is important. Adult children who are well into their careers have sort of a worse claim than a younger child who's maybe starting university or just starting a career and has a bunch of debt or something like that. Likewise, finances of the parties. The rich applicant has a worse case in general than the poor applicant. If the applicant made a contribution to the willmaker's estate, that can be really important as well. And the classic ones, there's a few cases from the 80s and 90s with these old rancher guys who, their spouse and the children contributed their whole lives, especially when the children were minors, to growing this estate that usually was always in the husband's name. And then the husband would pass away and he disinherited one kid, or he only left a little bit to the spouse because he didn't think she could take care of money or something like that. And in those cases, the applicants were really able to make a good claim. Like, look, I worked, 8 hours a day on my dad's farm for Michael until I was 20 years old. And now he leaves me nothing because he disapproved of something my son did or the woman I married or something like that. That's just not fair, right? So that gives a heightened obligation when there's that contribution. You see that with family businesses as well. You also see that with a spouse providing caregiving services at the end of someone's life is often a way that contribution comes. A person's sick for 5 or 6 years and the spouse is the primary caregiver. That's a pretty significant savings to the estate when you think how much they would have had to pay if that spouse hadn't been there. The nature of the relationship between the will maker and the applicant is really important. You see this a lot with children applying and saying, I've got I should have a good claim because I have a really close relationship with Dad, and I have no idea why he left me out of his will. On the other hand, if there's an estrangement, if the parties hadn't spoken in 20 years, then that's going to reduce the impact of that claim. Although sometimes, if the court decides that the estrangement was actually the parent's fault, then the court might say, you know what, you still owe that person an obligation. It was your fault that you had this poor relationship, and the willmaker should have provided for that kid. Something else that could be really important is money that passes outside the estate. So sometimes you see, there's a big part of the estate is in a RIF or something like that gets designated to one beneficiary, and now the other ones have a better claim to get maybe a bigger share of the estate because a big chunk gets passed outside. And the courts are always supposed to pay heed to testamentary autonomy, and this is mentioned in Tatter. You're supposed to disturb the will as little as possible, only if necessary, and not just rewrite the whole thing as if you think how you think it should have been written. Although sometimes it seems like the court does that. They change a whole bunch of things and mess with how the testator wanted things. Seems like more than necessary, but you're not supposed to do that. So because of all these sort of different factors that can be considered, one of the things I look at from a litigator's perspective is it's really, really hard to give someone a range of what they can expect to get or what they expect to pay in these kind of challenges. So someone comes in your office and they give you the background and you say, well, you've got on these factors, you've got a pretty good case and you could get up to 30 or 40% of this estate. But if the judge decides that these other factors are more important, then the 10% you're getting is fair. And so, there's a chance you could get nothing more than that. And so sometimes it's quite a leap of faith for people to jump into that kind of litigation, even if they feel like it's unfair, because of all these different factors, we don't know which way the court's going to decide. And it's also can be quite difficult to settle because one side's going to think that the court's going to think their factors are most important, and the other side thinks the court's going to think their factors are more important. And so you end up with, one side thinks that it should be a third, and the other side thinks it should be 2/3, and it can be hard to bridge that gap sometimes. So the lack of certainty in the law does sometimes make it more difficult to settle these kind of cases. My finding has been, since I started practicing this area 5 or 6 years ago, the sort of big area of action is blended families. So it's the classic, the new spouse against the kids from the first marriage. And those are, those are quite difficult cases because both parties can really make a really compelling argument. The new spouse says, look, I made, the will makers last 10 or 15 or 20 years. I made them the best years of his or her life. I was a, caregiver for a long time, and maybe I gave up a career or something like that to be with that person, or I moved away from my family to be with them, and that grounds a pretty strong obligation. And what the kids say, and this is normal case, obviously there's lots of wrinkles, but in a normal case, the kids say, well, my parents' estate was built up when they were together, and then, mom passed away, and it all went to dad. I didn't get any of it, and now dad's new wife is supposed to get the whole thing. That's not fair. Mom wouldn't have wanted that. That's not what they would have wanted when they were building up that estate together. So both sides have those compelling arguments to make, and for me and for advising my clients, it would be really nice if the Court of Appeal or the Supreme Court of Canada could take one of these cases and tell us here's what you need to consider when you're dealing with these kind of blended family cases. Because if you remember Tattern, which is the last time, to my recollection, the Supreme Court's dealt with the Bill's variation, was not a blended family case. It was a nuclear family. It was the wife and the 2 sons, and the deceased was the father. So it would be nice to get some more direction from the courts in what to consider here, because you can see the trial level courts, the decisions are quite inconsistent. There's some decisions where the court says, you know what, this was a 20-year relationship, this spouse just should get most of the estate. And there's other cases where the courts say in a relationship similar duration, they say, you know what, the estate was built up under the previous relationship, those kids should get most of it. So it can be a tricky thing to try and advise people on. So yeah, those are some of the factors that are foremost in my mind when I'm advising clients about wills variation. It's not the biggest area of my estate litigation practice. It is, for a lot of people, it's their primary area, but it's not for me. But I have had, like I said, a couple of these spouse cases where the deceased has passed away, and in a couple cases, the deceased, didn't update his will after the relationship started. And so basically the will was, had been made 10 years before the relationship was, 8 years in duration. And so the will was almost, it was difficult to put much weight on it because it was done before the relationship even started. So as a result, if I ever tell people about planning their estates, I always say, make sure you update your will when circumstances change, new relationships. And that's something for people to keep in mind as well. Anyway, that's sort of how I present wills variation, or how I think about wills variation arguments and positions. Does anyone have any? Yeah. Oh, sorry.
Do you have any comment on mutual wills agreements, and have you had any experience with that?
Yeah, I've had a couple where the parties either they make a mutual wills agreement, or they have a. Oh, okay.
Yeah.
Well, sometimes when, especially second marriages, parties will make a mutual wills agreement or some kind of cohabitation agreement that includes a term that, I understand I'm only going to get this from the estate, and that's it. For my partner's estate, if they die first, and that's it. And I'm fine with that. I give up my right to get anything more. So one thing to keep in mind with wills variation is you can't contract away the right to vary someone's will. If you're a spouse or a child when the person dies, you can't have, the court won't find that you contracted away the right, and therefore you have no standing. So that's the first thing to consider. So those kind of agreements aren't necessarily effective if they say, I will not sue to vary, my partner's will if he were to die first or she were to die first. But where they do come in is where the court says, well, when I have to assess what the legal and moral obligations are, I need to consider the agreements that the parties made. And I need to consider, first of all, whether those agreements are still operative, and the court will often apply the family law principles, which I don't know to what extent you guys have studied. The family law principles are whether an agreement's still in force. I think there was a case called Hartshorn or something like that, where those agreements were put under the spotlight to see if they're still enforceable. And if they're still enforceable, the court will enforce them to the extent that will inform the court's understanding of what the moral obligations are. In particular, the moral obligations, sometimes the legal ones as well. But so in general, let's say the classic example is the spouse. They have, at the start of the relationship, they make a cohabitation agreement or a mutual wills agreement that leaves that tends to give most of their estate to their respective children, and the spouses may only share a little bit, if at all. Then 20 years passes. Now they stay in a relationship, they cohabitate. Maybe the last 5 years or more, one of the spouses takes care of the other one. That one dies. Now the new spouse, the spouse says, well, it's a 20-year relationship. I was the primary caregiver for 5 years. Is it really fair to hold me to this agreement I made 20 years ago when the circumstances were totally different? The estate may be way bigger. Maybe they had some successful financial investments. Now the estate's worth 3 or 4 times as much as it was before. And the courts will often give some credence to that argument and say, well, we have to respect the contract, but in the light of the changing circumstances, it doesn't. I'm not going to negate the claim just because of the contract says so. I'm going to give it less effect than I would otherwise because the contract is there. But the spouse has the right to share in some of the benefits of the grown estate, or some of the fact that she provided caregiving services or whatever. Anything else on wills variation? If not, I'll turn over to the next. So the next thing I was going to talk about was as I said, the presumption of resulting trust. And there was a huge decision in 2007 called CORE, Supreme Court of Canada decision. And essentially what this decision might be the single most important decision in the estate litigation world. And pretty big change in law, and also in the way that practice had to be done afterwards. So what the court did was clarify the law around transfers that are made prior to a person's death. And in particular, gratuitous transfers, right? Transferring property or bank account or something like that to your kids or to your spouse. And it included putting that person on as a joint owner on the asset. So prior to the court, those sort of transfers, gratuitous transfers, there's always been some litigation around them. And one party, the recipient of the gift of the transfer, saying, no, it was a gift, they wanted me to have it, I was supposed to keep it. And the other party, so either the person who transferred it or their estate, is saying, no, 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 I didn't intend it to be a gift, or that person didn't intend to be a gift. They were just going to hold it in trust for the transferor until something happened and they were supposed to transfer it back. So some of the reasons why that might happen, just because it might not be clear at first glance, some of the reasons why you might want to transfer one of your assets to someone else or put someone else's name on an asset, even if you don't want that person to have it, would be like avoiding probate fees, allowing the recipient to deal with the asset. So if you're an aging parent, you put your kid on your bank account so that if you become incapacitated, your child can go down and take money out for you, pay bills, and that kind of thing. Like a cheap power of attorney kind of. For convenience sake, it's easier to transfer property to a joint owner than it is if there's an estate and you have the executor has to transfer to themselves, and then they have to have the appropriate, then they have to transfer to themselves, then they have to sell it, distribute it to the beneficiaries. If the executor is a joint owner on the asset, it's easy. They go down to the land title office, and it's a matter of a form and a death certificate to do it. And another thing, we were just talking about will's variation. If you manage to put all your assets into joint names or give them all away, and if you've got a child you really want to disinherit, they've got no estate to go after. So that's another reason why people might transfer their assets away before they die. So those kind of transfers were always happening. There was always some litigation around them. And so the courts, hundreds of years ago or 100 years ago had figured out the key point is the intent at the time of transfer. So was at the time that that person signed the document or gave the asset away, what was their intention? Was the intention to gift, or was the intention that that person they were giving it to would keep it, hold it in trust for them? But of course, since very often that the transfer had died before the litigation, it was difficult to get that evidence. And even if the transfer hadn't died, then and they wanted the asset back, of course they're going to say, I didn't intend it to be a gift. So the courts said we have to look at the objective evidence, and where that's not clear, we need to apply presumptions. And there was two presumptions that could be applied before Purport. The first one was called the presumption of resulting trust. And that said an asset that's transferred gratuitously was presumed to be held in trust by the person who received it. And that arose from back in the courts of equity back in the medieval ages, there was an adage that equity presumes bargains and not gifts. So the presumption had to be that that was being held in trust and it wasn't meant to be a gift. But on the other hand, you had the presumption of advancement, which said that an asset that was transferred to a spouse or a child was presumed to be a gift. So before Purport, again, it was clear if it was an asset transferred to a friend or something like that, a non-family member, then that was fine. It was clear that the presumption of resulting trust applied. But assets transferred within the family, which was obviously much more common, there was these two different presumptions that the courts could apply, and the courts were very inconsistent about which one they applied. Remember, the presumptions aren't conclusive; they're just tiebreakers, right? If there was no objective evidence, the presumption would just break the tie one way or the other. So what the court of Purport had to decide was, in that era, more and more people were using it, particularly joint tenancy, as a cheap estate planning tool. And so more and more these things started getting litigated and were increasingly litigated, and the inconsistency between the two presumptions was becoming more troublesome. So the court of Purport had to decide, which presumption applies in the case where an asset's transferred into joint names with an adult child. And so basically, the most important thing to come out of Purport was that the presumption of resulting trust would trump the presumption of advancement when it came to adult, independent children. So that meant, of course, that assets transferred to adult, independent children, including into joint names, were now subject to challenge. And they would always been subject to challenge, but now they're subject to challenge in the circumstances where that child has to rebut the presumption. So they actually have to have some evidence that would show that a gift was intended. So it gave rise to a whole host of litigation and then the classic situation is the beneficiaries, the other children, for instance, of the estate, and they challenged a transfer to the executor that happened before, and they say, no, the executor was supposed to hold that in trust for the estate, And the executor says, no, mom wanted the property to be mine. And that's sort of, to me, anyway, the classic Pecor situation. And so that's what it clarified, is that in that case, it's the presumption of resulting trust that applies, and not the presumption of advancement. So for presumption of advancement still maintained where the parties were spouses, or where the transfer was to a dependent child. The other important things that came out of the Pecor case, the court clarified that when assets are transferred to joint tenancy, they're subject to basically exactly the same analysis and the same presumptions as an outright gift. So if your mom puts your name on the bank account as a joint owner, it's the same analysis if she just put your name on it as a sole owner. The question is still, it's a gratuitous transfer. There's a presumption. The presumption is that it was meant to be held in trust. Another thing that the court sort of clarified in the court case was about what evidence the courts could consider. There used to be an old rule that the courts, because the question was intention at the time that the asset was transferred, they couldn't consider anything that arose subsequent to that. No subsequent evidence could be considered. And in the court, they said you can consider it, but you have to be careful that it's evidence that actually relates to the intention at the time the transfer happened, and not a changing intention after the transfer occurs. And in Pecor, actually, it was subsequent evidence that was the key for the court. That was a case where the father had transferred an asset into joint names with his daughter. His will, for some very odd reason, named the daughter and her husband both personally as beneficiaries. And of course, what happened is the daughter and the husband broke up. The daughter was the only one getting this asset outside the estate. So the husband brought a challenge saying, no, that asset really should be in the estate. It shouldn't go to the daughter. It should go through the estate so I get my share. And the
Oh, sorry. You can keep going.
and so and the court said in that case there was very little evidence about the intention at the time of the transfer. But a few years later, the father went to meet a lawyer to redo his will, and he talked about a whole bunch of his assets, but he didn't talk about this asset he had put into joint tenancy with his daughter. And so the court inferred from that he realized or understood that he had already given that asset away, that it wasn't going to be dealt with in his will. And that was the principal evidence that the court used to decide to rebut the presumption and say that the asset does go to the daughter. So this Pecor case made a really significant change in the way that asset transfers are analyzed and treated, both on the solicitor side and the litigation side. From the perspective of the solicitor, or in some cases the notary or the banker, who's on the business end, actually trying to put these changes into effect, affect transfers that their clients want to do. Pecor really demonstrated the importance of making sure that the client thinks clearly about what their intentions are. Sometimes the client might come in and say, well, I want to do this, transfer this property into my joint names with my daughter because it'll be easier. And it's really important to make sure they think clearly about what's going to be easier. Is this to avoid probate, or do you want her to have the asset at the end of the day, or is she supposed to split it with your other beneficiaries, or what's supposed to happen? Documenting the intention at the time of the transfer is really important. It's something that wasn't done as much before. The importance of that is really huge now. And that the client understands the risks of making that transfer. Right? And there's a whole bunch of risks with putting an asset into joint tenancy, but obviously one of them is that your other kids or your other beneficiaries can litigate this and go after your executor, go after the person receiving the asset, and end up spending a whole bunch of money in litigation and maybe tearing the family apart. That's a risk that people need to know when they're thinking of doing this. From the litigation side, I wasn't practicing when the court came out, but having gone back and read the old BCCLE papers and stuff that came out around this time, a lot of the litigators were just going, wow, look at this amazing area of law that some of us hadn't really thought of before, and now it's front and center, and the courts have given us this great tool to go after these transfers, that in most cases, because there's so many of them that happened before the court decision came out, no one was documenting them, or very few people were. A lot of them were done without any professional advice whatsoever. So there was no lawyer or notary who could stand back and say, oh, no, we may not have documented it, but mom told me she wanted this and this and this to happen. So a real, ticking time bombs of litigation out there everywhere. And so, the litigators are really rubbing their hands together. Basically, it's these gratuitous transfer issues are a big part of estate litigation. There's cases coming out about them all the time, and really, the courts are still working through the issues with those. It's complicated. Joint tenancy, remember your first year property law stuff. It's complicated. You got the four unities. In these kind of situations, sometimes it's difficult to figure out, do the four unities really apply? I mean, you take an example like the elderly mom puts her daughter on as a joint owner of her house in joint tenancy. But let's say the mom's really private. She doesn't give the daughter a key. The daughter understands, I don't go in mom's house unless I'm invited. So when you think about something like a unity of possession, does that ever really arise? Is it really a joint tenancy ever? Those are the courts are, and I think the lawyers are realizing they can argue those issues, and the courts are now having to figure out how to deal with them. And so you see some very interesting and complicated property law arguments come out about, how the joint tenancy should be applied, and what happens if, for instance, on a bank account that's in joint tenancy, what if one of the parties removes all the funds? Does that sever the joint tenancy? Or does the joint tenancy remain over these funds that have been removed? There's a lot of complicated questions out there that I think everyone's still sort of working their way through about how to apply these things. So I was going to talk about powers of attorney and comitations next, unless there's any questions about. Yeah.
How do you spell the case?
Pecore.
And another question is, how would you recommend then the best way for a donor, if they're giving gratuitous gifts, to avoid probate fees? What's the best way to do it? Then give fee, or you want to explain this to avoid probate?
The best way is to have a document prepared at the same time that says, this is what I want to happen to the asset. So in the case where they just want to avoid probate fees, and they want it to go to want it to be divided amongst their kids, you say, you have the ones that I've seen anyway, sort of an introductory section that says, this is the asset that I'm transferring to this person. This is what I intend to happen with this asset. I intend to be the sole beneficial owner during my lifetime. I will pay the taxes. I will, whatever. And then they go on to say, upon my death, I intend this asset. I intend so and so, the person I'm transferring it to take this asset and sell it and divide the proceeds amongst X, Y, Z per people. It's the best to be as clear as you possibly can with it. And one of the things that avoids, in particular, when we're talking about property, is a situation where you put your property into joint names with your two kids. One of them's in business. They run up some debts. They get judgments against them. The first thing the judgment holders do, even before they get judgment, is they're going to run out and find out what properties that person has. They do an LTO search for that person's name. Boom, up comes your property with your name on it, and they stick the judgment against it. And so if you've got a document like that, then that's really the only good way to get that judgment holder to take off. Otherwise, if you just say, oh, no, it's supposed to be mine, they might say, well, too bad, it's in that person's name. You've got to prove it to me. And so that's the way you get out of those kind of situations. At least the only good way.
So do you want to comment on how the financial institutions have responded to the COLA?
My sense is they're only really starting to do it now. It took them a long time. The banks apply the opposite presumption. It seems, in most cases that I've dealt with. They prepare a bunch of documents to say, this account is a joint account with joint tenancy with right of survivorship. Sometimes they just say JTWROS. And then there's some complicated banking agreement that the people sign that usually suggests that it's a real right of survivorship, that the surviving owner is supposed to get all the funds in the account, but doesn't really do it effectively. And if you read the core actually was the first case in a companion. There was two cases that came out as companion cases. The other one's called Madsen Estate and Saylor, Madsen. And in that case, the presumption was upheld, and the transfer was found to be a resulting trust. And in that case, they had the banking documents. It was a bank account. They had the banking documents that said, that had some language in there about the surviving joint owner will get the account and so on and so forth. And the court said that's not good enough. It needs to be a lot more clear than that and say what's going to happen to the beneficial ownership of the funds in the account. That's the important thing. And the banks, I have some sense now that they're starting to change their forms and their approach, making sure that if someone comes in and says, I want to put my daughter on the account, here she is, they don't just get an agreement and sign it. They actually talk to them a bit. But it's been a while to get them there, and a lot of them just continue to do business the same they were doing, and of course made a bunch of risk for their client who they weren't ever talking to or giving clear documentation to. If you sign this is what you're doing, and I think too the other thing, not giving people the option of saying, well, which one do you want? Do you want this to go to your daughter when you pass away, or do you want it to go to your estate? It would just be they just say joint tenancy. Okay, same form, sign away. So the banks, I think, have taken a long time to adapt to it. I think they're starting to now, but I'm not sure, because I usually get things from a few years ago that cross my desk. I don't get the brand new form, so I'm not sure to what extent they've done it, but I think they're starting to. Yeah.
How can someone document a change in intention? Because you said it's very important, the intention at the time that they name someone on their property or in their bank account as beneficiary. If their intention later changes, how would they report that? And does it matter that the intention formed separately or at a separate time than the actual transfer occurred? How would that affect the court's decision?
That's a really interesting question. So I don't know if everybody heard. The question is how would you or how could you, can you document a change in intention after the transfer? So there's actually a case that came out and then got appealed, and the appeal was successful. A BC case, I can't remember the name of it. It's Mick something. The case I think was 2 years ago, and then the appeal was last year. And in that case, the judge applied a really technical approach to that. The judge said, look, the court says that I need to consider subsequent evidence only if it relates to the time of transfer. And what had happened in that case is the mother had put her son as a joint owner in her home. But it was pretty clear when she did it that she only intended that for convenience sake, to try and avoid probate and to make it easier to transfer after her death. But then as time went on, her estate plan changed, and it became clear that she actually wanted him to have the house, and she tried to document it in a couple different ways. If I remember right, she signed, I don't know what they called the document, a deed of gift, perhaps saying, when I die, I want my son to have this property. And I think when she was doing her new will, she prepared something along the same lines that was included along with her will or something like that. And that first judge said, no, that's evidence of changed intention. Her initial intention was that if he would hold it in trust, and that's what we have to go with. And the Court of Appeal said, look, she did, at the time she transferred it, yeah, her intention was just to give it to him in trust. But what else was she supposed to do when her intention changed? She'd already put him on title as a joint tenant. There was nothing else, practically speaking, that we should require her to do. And then she documented her intention. And maybe she should have said it's now changed or whatever, but she documented it, she put him on as joint owner. What else do we really expect her to do? Maybe the only decision in recorded history with the Court of Appeal was more practical than the trial court. But that's how you do it. On the other hand, you might not be able to do the opposite. If you've already given the gift, then it's given. And I haven't seen a case like that, but I would presume that would be a pretty strong argument that no, once the gift is given, you cannot take it back and say, no, actually, now I only mean you to have it in trust. Because that's my understanding of gift law. Once it's given, you can't take it back.
You probably could still go start with a tenancy lease and preserve half.
Yes. Yeah, I think that's right. So you sever the tenancy and you get ownership and tenants in common. And then you lease the half interest will pass through your estate. And obviously there's, when we're talking about these kind of assets, joint tenancy transfers, there's a couple different possibilities. There's a possibility that you actually intend to give it as a gift immediately, and you're only leaving your name on it for convenience sake or something like that. And then there's the possibility, more likely, that you intend it to be a gift once you die. So that comes into it as well.
Yes. In that situation of the joint tenancy, if one of the parties were to go bankrupt and the creditors were to come after that property,
Yeah, so if you had an instance, and I don't see why this hasn't happened, I don't remember seeing a case on it, but where the contest was between creditors who were after one of the joint tenants versus the other joint tenant who says, no, I'm the real beneficial owner. The presumption of resulting trust would absolutely apply in that kind of situation. So if they were going after the party that, like the child, let's say, who just been put on title, the parent could still say, no, I'm the only beneficial owner. That was just, that was intended to be a transfer just of title, not of the beneficial ownership, and the presumption would apply in their favor in that kind of situation. But again, the court in that case would be very suspicious of changing intention because it's hugely in the transferor's favor to say, oh no, I'm actually still the real owner, despite my having signed this away to my child. So the court would have to be very suspicious about it. And really, some of this area are people who are still alive, and they've now had a falling out with their child, who they put on title. And now it's 10 years have gone by, they've had a falling out, and now the child says, no, you put me on title, pay me off, pay me my half. And I've had to deal with a couple of those situations, and those are, essentially the child's extorting their parent, and really, really difficult. You're telling the parent, well, either you can sue your kid, or you can pay them out, or you have to stay there. You won't be able to sell it and move to the retirement home that you want to go to because your child says, I won't sign unless you pay me. So those when I try and tell people and scare them about doing joint tenancy, that's my best example. Those are the worst cases because it's like this super poisonous family anger, and you have to give this terrible advice to this poor elderly person about suing their kid, and they're like, what, I have to sue my kid? And in the one case I had, it was the father who had orchestrated it all, and he had died, and now mom was the one left holding the bag. And she said, I don't know why we did this. I just went to the lawyers and signed the papers. And it was 15 years ago, and it was all my husband's doing. I didn't have anything to do with it. Now I find out that my son says he owns half the house or whatever. Like, it was really, really bad situation for her. Any other questions on joint tenancy? All right. So I was going to talk a little bit more briefly about powers of attorney and commutation. So I've run across these a few times in litigation as well, issues with them. So for powers of attorney, the three areas I've seen litigated are they valid, right? Just like a will, powers of attorney need to be valid. The person has to have capacity to make one. They can't be unduly influenced into making it. And so they can be challenged for that reason. And that's not very common. The situation in which that I became involved with it was I was acting for the fellow who had the power of attorney, and he had found out that his, I'm trying to remember the relationship now, I think it worked out to like his uncle's new wife or something like that had basically taken much of his money. And so he got power of attorney and said, well, I want you to write a demand letter and demand the money back. And so when we did that, the wife said, oh, I question that validity of that power of attorney. Does he really have capacity, and so on and so forth. So we ended up in a bit of a battle about that. And related to that, the second area that I see litigation on, the attorney not acting in the best interest of the beneficiary. Obviously, the attorney has a fiduciary duty to the beneficiary's interests, but sometimes attorneys confuse their own interests with those of the person they're acting for. I had a case where the estate was worth almost, not very much money, $200,000 I think max, with 4 siblings, so they're each maximum line to get $40,000 to $50,000. But there was one of the sisters was maybe the most vindictive person that I've ever come across. We called her vindictive sister. That's how we referred to her. And she had got, before mom died, she'd got power of attorney, and was essentially using it to start litigation against her siblings, just to attack them. Like, the litigation had a very thin foundation of fact. It was really just to put her siblings to pain because she had hated them for a long time. They had fallen out 20 years before, and it was very difficult. So then mom died, and then she kept pursuing this litigation, and we had all sorts of problems with whether she had standing to do that or not, and who should have the right to do it. The mom had appointed two lawyers to be her executors, who immediately renounced because they wanted nothing to do with the situation. And it was a very difficult case where this sister, in our view, was clearly using her power of attorney to go after the siblings, and in no way was acting for the best interests of mom. Another way to get litigated is the attorney overspends, tries to charge significant fees, or basically kind of well, mom wanted me to have a gift, so I bought myself a drum set and it cost $10,000, so she wanted me to have it. So and attorneys need to remember they need to account just like any other trustee. They can be called to account for monies they've spent on behalf of the beneficiary for things that have disappeared from the beneficiary's accounts. And I had a situation where I had to defend a client like that who had power of attorney for her grandmother. And was saying, grandma wanted me to have this and this and this, and she gave me this, gave my husband this present. And it's a very difficult thing because of the fiduciary duty to try and justify that, grandma wanted me to have these things. And I had a case, actually, this is still a funny one. I had a case a few years ago where we were acting on behalf of the executor, but the power of attorney was a different sister. And once my client took over as executor, we saw these transactions. We went, what are these for? And we found out that this is quite an artsy family. We found out that the sister, when she'd had a power of attorney, had charged mom like something over $20,000 to produce an opera about mom's life. Produce and perform an opera about mom's life. And that was that they were defending that expense. It's like, mom wanted that. She wanted to pay me and my husband to write this opera. It was like, it was an interesting case. We ended up settling it. It wasn't, we were questioning maybe $7,000 or $8,000 worth of expenses, and she eventually came up to a point where I told my clients it's probably not worth it to go after it anymore. But it was that, and it was she insisted that she needed to go back and forth between Vernon and Towns like 150 times, so she was charging mileage each time, and then she was trying to charge fees even though the private company didn't let her charge fees, and so there's a whole bunch of things that made it up. Eventually we resolved it, but it was this opera thing was really, what some of the lawyers in my office were saying, you can get production, you gotta send them they have to send you the audio tapes and all the music and everything for the opera. So those are the kind of things that can happen with the power of attorney, issues that get litigated. For committeeships, there's sometimes litigation over the application itself. So one party applies. You have to serve the patient with the material. So sometimes the patient says, no, I'm capable, I don't need a committee. And you have a fight about that, whether the patient needs a committee at all. And the second kind of challenge that happens is another interested person, so when a sibling or something steps up and says, no, that person's not appropriate, I'm going to apply it, and you have these two competing applications. And then the courts have a list of factors they consider in deciding who's the most appropriate. And sometimes a public guardian trustee gets involved as well too. If they don't like the person who stepped forward, they can get involved and say, no, they're not an appropriate committee, or they are, but they need to have these conditions. They got to put up a bond or something like that. And so you can have a battle about that. And then, like powers of attorney committees, again, they're trustees, so they've got to account for their dealings with that person's money, and that's in terms of expenses and fees and all that kind of stuff as well. So you can end up with litigation about that, and often again that happens after the person's died, where the other beneficiaries say, wait a second, mom's estate was worth this much, and then the committee and ship order happened, and now it's only half as much. Where all this money go? When you find out the committee's been spending it on themselves or what have you. So those are sort of the litigation that comes up with committeeships. So that's essentially what I wanted to say on that. Any questions on powers of attorney and committeeships?
Would you suggest it's beneficial then to have a different person to act as a power of attorney than it is to have them act as the executor of the will, so that there is like that internal checking?
Check.
Yes,
It can be in some situations. I mean, hopefully you trust the person you choose for either role to the extent that you don't need to think about that. If for some reason you're in a situation where you need to appoint a power of attorney you think might take some shortcuts or something like that, then it's a bit of a check and balance. I mean, the problem is, of course, is by the time you die and it gets turned over to the executor, the money's probably gone. And a lot of what happens is, and the way we settled that opera case was, you end up with a deduction to that person's share of the estate. They don't end up paying any money back. It's just that instead of getting 100, you're only getting 50 now because we found you stole $50,000. And so sometimes the battle only comes out when the executor is trying to get the beneficiaries to approve their accounts, and that's when you have the negotiation about, well, how much should Brother Rick get, because we know he stole this money from Dad when he was alive, and he had power of attorney or whatever. So you end up in a complicated battle with that, and all sorts of deductions being made, and fights over, well, no, this item is fair, this item. So yeah, it can be a bit of a backstop, but hopefully not one that's required. And if you don't trust the person you're appointing, and you think they need a backstop, maybe appoint two people, right? If you got two kids, and that can be problematic as well for its own reasons. But that's a way that if you don't completely trust one or the other, that you hope they hold each other to account. Then again, maybe they just get to cahoots and steal all your money. So.
All right. Any last questions?
Yeah. Anything else? Like I said, I'm happy to talk about anything, thoughts or anything that arose from that.
Right, well.
Thank you guys very much.
Thank you. 10 minutes. Welcome to Figaro. Thank you so much. That was fabulous.
I had it muted for a while and then I wasn't sure.